Welcome everyone to this new episode of the Privacy Rules, Privacy Espresso series, a series where we delve into the latest news on privacy, data protection, but anything related to technologies such as cybersecurity as well as AI from all over the world. Today with me, I have two experts from Canada, which are Lindsay A and Kristen Pennington, which are partners from the law firm McMillan LLP. They are both coming from the team of privacy and data protection in the firm, and they are great experts in these sectors, which is why we're having them with us today. There are indeed some pretty relevant news on the topic coming from this jurisdiction, so I'd be more than happy to go through them in detail together with these two experts. And I think that the best way would be to start by leaving the floor to you immediately. Maybe I can start immediately with Lindsay. Lindsay, I understand that there has been some significant development in relation to privacy regulation in Canada. So can you give us an overview on what we're talking about?
Sure. On June 15th, Canada's federal government introduced Bill C-36, an act to enact the Protecting Privacy and Consumer Data Act. If passed in its proposed form, Bill C-36 would create new federal private sector privacy legislation, the Protecting Privacy and Consumer Data Act, or the PPCDA. This legislation would replace the privacy-related terms of Canada's existing Personal Information Protection and Electronic Documents Act, or PIPEDA. Like PIPEDA, the new act would apply to an organization in respect of personal information that it collects, uses, or discloses in the course of commercial activities, as well as personal information about employees or job applicants that's collected, used, or disclosed in connection with the operation of a federal work undertaking or business.
Lindsay, listening to you, and thanks a lot for the overview. I must admit that this is not sounding new to me. So, you know, is this not the first attempt of a reform in Canada, in particular for the private sector privacy legislation, right?
Yeah, you're absolutely right about that. There have been two prior attempts to overhaul Canada's private sector privacy legislation. So Bill C-36 contains a number of similar elements to those previously proposed bills. We had first Bill C-11, which was introduced in November 2020, and then Bill C-27, which was proposed in June 2022. And both of those bills died on the order paper when each of Canada's last two federal elections were called. So now the government is trying again with a similar but not identical proposed law to substantially replace PIPEDA.
Lindsay, thank you very much for the overview and also for those additional detail that makes much more clear on what's happening at the Canadian level. Maybe we can pass the word to Kristen in this case. Kristen, I'd like to ask you if there are any insights in your view that might have motivated this recent round of proposals of changes in relation to privacy reforms in Canada.
Absolutely. So Canada's federal government recently launched AI for All, which is a new national strategy that's designed to increase AI innovation and adoption in Canada. The government has confirmed that Bill C-36, and in particular the passing of the PPCDA, is a key element in advancing this new AI strategy. And in particular, the government is of the view that modernizing and strengthening Canada's privacy laws is essential to mitigate privacy risks associated with the development and adoption of AI and other digital technologies, and to foster the public's trust in their use.
And is there, any, let's say, key requirements that this PPCDA is going to introduce, Kristen, in this regard?
Yeah, absolutely. It is a bit of a mouthful, the acronym, at least as it stands right now. So the PPCDA would represent the most significant change to Canada's private sector privacy legislation in more than 2 decades, at least at the federal level. And if passed in its current form, it would introduce a number of new measures that businesses would have to incorporate into their privacy compliance programs. So we won't have time to run through all of those potential changes today, but I do think there are a few that are particularly noteworthy. One of which is that the PPCDA would require certain notices to be provided in plain language at or before before the time of seeking an individual's consent to collect, use, or disclose their personal information. So those notices would include the purposes for and any reasonably foreseeable consequences of the collection, use, or disclosure of the personal information, the manner in which that personal information will be collected, used, or disclosed, the specific type of personal information that you'll be collecting, using, or disclosing, and finally, the names or types of third parties to which the organization may disclose that personal information. Another interesting development is that unlike PIPEDA, the PPCDA would expressly address the cross-border processing of personal information. So more specifically, before disclosing or transferring personal information outside of Canada, an organization would be required to carry out a privacy impact assessment, or PIA, and then mitigate any risks that are identified in that PIA. And then on request, the organization would need to provide the regulator with either access to or a copy of the PIA itself. And then finally, the PPCDA would go one step further than PIPEDA by setting out certain factors that would need to be considered in determining whether a purpose for and a manner of collecting, using, or disclosing personal information is appropriate. So organizations would need to consider, among other things, the degree of effectiveness of the intended collection, use, or disclosure of personal information in meeting the organization's legitimate business needs, and also whether there were any less intrusive means of achieving those purposes at a comparable cost and with comparable benefits to the organization.
Kristen, this sounds as a definitive step forward in terms of strengthening the privacy data protection practice in Canada. I heard your list with great interest, and there is indeed a lot. And as you were saying, this was just part of the changes, and thanks a lot for highlighting the key ones with us. I'm just curious to know about one specific that I didn't hear about, which is the one of the data subject rights. Is there anything specific that we should know about that?
Yes, absolutely. So the PPCDA would also impact data subjects' rights. It would introduce, in particular, new rights around the use of automated decision-making systems to make predictions, recommendations, or decisions about individuals that could have a legal or similarly significant effect on them. So on request, an organization would be required to provide the individual with an explanation of that decision, as well as an opportunity to make written representations to an employee of the organization who can review that decision. The PPCDA would also introduce the right to request that your personal information be disposed of, and also a right to ask that your personal information be disclosed to another organization. So in other words, data mobility right, but in each case, subject to certain conditions and exceptions. And then finally, interestingly, the PPCDA would expressly recognize that individuals have a fundamental right of privacy with respect to their personal information, although I think the practical implications of what that recognition means remains to be seen, but it's certainly been buzzworthy.
Okay, that sounds really interesting, and thanks a lot, Kristen. I think that we have now more or less a clear picture on the key and relevant changes that this new framework is going to apply. My next question would move a bit more into the practical part of that, and maybe Lindsay, you can come back in for this one, also based on your experience, right? So, in your view, are those changes that can be welcomed by businesses or not?
Yeah, I mean, some of the changes that Kristen mentioned, I think, are not completely different from how PIPEDA has been interpreted in the past. But I think there are some proposed changes that we haven't touched on yet that are likely to be welcomed by business. In particular, I think some businesses will be happy to see that the proposed legislation moves away from the strict consent model that currently exists under PIPEDA. The PPCDA would introduce new, broader consent exemptions that allow organizations to collect and use personal information for certain defined, reasonable business activities. So, for example, consent would not be needed to collect or use personal information for an activity that's necessary to provide a product or service, or when necessary for IT security purposes or product safety. Also, organizations would be able to rely on legitimate interests to collect, use, and disclose personal information, which is a concept that will be familiar to organizations that are also subject to the GDPR. But each of these exceptions is subject to certain conditions and limitations. So, for example, organizations cannot rely on either of these new exemptions if they're collecting, using, or disclosing personal information for the purpose of influencing an individual's behavior or decisions. Also, before collecting, using, or disclosing personal information without an individual's knowledge or consent on the basis of legitimate interests, the organization would have to carry out a privacy impact assessment. Another feature of the new act that many organizations will likely consider to be positive is that it would allow them to use an individual's personal information to de-identify or anonymize the information without consent. This will be helpful to allow organizations to leverage their data to improve their products and services and the efficiency of their business operations. But the PPCDA would also place certain obligations on organizations that de-identify information, such as to consider the risk of an individual being re-identified when the organization is applying technical and administrative measures to the information. Finally, and in my view, one of the most positive developments is that, unlike PIPEDA, most provisions of the PPCDA would not apply to a service provider with respect to personal information that's transferred to it by another organization. So, for example, only the organization in control of the information would be responsible for obtaining consent to process it when consent is required under the new act. Now, this is more consistent with the privacy laws in other jurisdictions that I'm familiar with, and it makes much more sense from a business perspective. However, this relief for service providers would not be absolute. They will still need to safeguard the personal information they process and notify the controlling organization of a breach of security safeguards under the new act. And also, other requirements of the act would still apply if the service provider collects, uses, or discloses personal information for a purpose other than the purposes for which the information was transferred to it. So what this may mean is that service providers will need to think carefully about the terms that they want in their contracts with their customers. Because if they seek to use the customer's data for any of their own internal business purposes, which isn't uncommon these days, they may then trigger this broader application of the new act.
Lindsay, that's extremely interesting, and I think these type of changes were long awaited. I mean, we've been discussing about Canada, and I still remember that every time that we were presenting on, or discussing with experts from other jurisdictions, they were really impressed by the fact that it was this only consent approach. Of course, you know, this also means broadening the space of maneuver for company, which of course is something very positive because give them an ease or easier access to data and to their use in the legitimate way, of course. But you know, it immediately rings the bell on the topic of enforcement, meaning, you know, how do we make sure, or how is the Canadian jurisdiction thinking of making sure that everything runs in the right way? So I'd like to ask you, do you see in Canada something similar to what we are seeing in the rest of the world, meaning a stricter enforcement trend, or it's a bit different? How is this under PPCDA?
Yeah, no, absolutely. Bill C-36 would significantly increase the potential financial repercussions for businesses that don't comply with the federal privacy legislation. So right now, the Office of the Privacy Commissioner of Canada can only make non-binding recommendations for an organization to correct its practices if the organization doesn't comply with PIPEDA. Although the Attorney General can levy fines, this is only for certain narrow offenses, and the maximum fine under PIPEDA is $100,000. On the other hand, Bill C-36 would introduce significant potential administrative monetary penalties for contravening certain provisions of the PPCDA, up to the greater of $10 million, or 3% of the organization's gross global revenue in the prior fiscal year. And it will also provide for fines of up to the greater of $25 million, or 5% of global revenue for certain offenses. Interestingly, the new act would remove oversight and enforcement of federal private sector privacy legislation from Canada's existing federal privacy regulator, the Office of the Privacy Commissioner of Canada, and instead place this responsibility with a newly established Digital Safety and Data Protection Commission of Canada. This new commission would have a variety of powers, including the ability to issue binding orders.
Okay, that's very interesting and unexpected to have a new authority and subject that would be controlling over. Just a quick question: would it be the same that apply any control on AI or is different?
So we don't have a comparator to the previously proposed Artificial Intelligence and Data Act. So there's another statute, which we're not going to talk about today, which does propose some new rules with respect to certain social media and online services, including AI chatbots. That's a completely different statute, but it would be the same new regulator who would have responsibility for both of those acts. And that's why you have the name of the new commission being what it is.
Perfect. And sorry for the off topic, but
no worries.
It's a big topic in many other countries, meaning that having too many authorities that you need to notify or to deal with, it's always a very relevant topic. And now I understand the logic behind this, meaning that there is already an authority that has been equipped for specific frameworks that are coming. So of course they are trying to give powers also to that one. Thanks a lot for this. I think that the missing part of our discussion that was amazing so far is the future, because we're still talking about a bill that needs to become law, as it is not yet. And my question to Kristen, to switch back to her, would be, Kristen, do you think that this time is the right one for the Canada federal privacy reform?
Yeah. I'm probably having a case of deja vu, because I think this is the third time that I've said, here comes the changes and this time will be the time. But I think there are several factors that we believe make it likely that Bill C-36 will be passed in some form. Unlike the last two attempts at reform that Lindsay referred to earlier, this time around the federal Liberal Party has a majority government. So an imminent federal election is unlikely. And PIPEDA is widely considered to be outdated based on global developments and technological developments. And the federal government, as I mentioned, has tied this round of proposed reform to its new AI strategy. So we think that modernizing federal privacy legislation will be a strategic priority for this government, and it's likely that we'll see Bill C-36 eventually pass in some form. However, of course, the final form of Canada's new federal private sector privacy legislation and the timing when it will come into force all remain to be seen. So just procedurally, Canada's House of Commons has adjourned for the summer, so they won't sit again until September. Once they do resume sitting in the fall, Bill C-36 will still have to pass a number of legislative hurdles. So that'll include, for example, a second reading where the bill's principles will be debated. Then there's typically a clause-by-clause review and proposed amendments after the proposed legislation is studied in committee. And then there's a third and final reading with further debate about the legislation, and then a similar review process within Canada's Senate. So, of course, our team will be continuing to monitor the progress of Bill C-36, and we'll see if there are any substantial changes that are made to the draft legislation as this process continues.
Thank you very much, Kristen, and I believe that of course it's clear that there is the willingness to change. So if not now, I think that one or the other will pass. But I think what is really important here to underline is the real change that we can see in this new proposition that leans the Canadian law much more closer to other laws and other jurisdictions that we see in the rest of the world, in particular in the EU. We have been talking about, legitimate interest, for example. We have seen that the enforcement measures are much stronger than before. So it's definitely a relevant change, the one that the Canadian government is willing to make. By thinking that one day or the other it will happen, and most probably this one seems to be, a good opportunity. My last question, in order to also close again with the practical side, is, what should companies that operate in Canada or that offer products and services in Canada or to Canadians, what can they do to prepare for this reform that is coming?
So we are already receiving a number of reach outs from organizations who are looking to better understand the potential implications of Bill C-36 for their businesses. So we can assist organizations with auditing their existing privacy compliance programs and conducting a gap analysis to identify areas in which there would be significant efforts needed to bring the organization or its products or services into compliance with the proposed terms of the PPCDA. But finally, although the changes that are proposed by Bill C-36 are significant, as Lindsay mentioned earlier, it's important to remember that a number of the provisions of the new act either mirror language from Canada's current federal private sector privacy legislation, PIPEDA, or reflect existing guidance that's already been issued by Canada's federal privacy regulator interpreting PIPEDA. So not everything is brand new. And so we can work with businesses to help understand what provisions of the PPCDA they really ought to already be taking steps to comply with based on the current state of Canadian privacy laws, anticipating that these requirements will just be backstopped by potentially significant penalties or fines and other new enforcement powers in the coming years if Bill C-36 passes.
Perfect, Kristen. I understand that many of those changes are somehow there already, so company should be already looking at complying with them, also in order to be in line with upcoming regulation, but of course, first of all, to be compliant with what is already there. We're running out of our time, so I'd like really to thank you, Kristen. Thank you, Lindsay, for being with us and for giving us this very broad and deep overview on what's happening in Canada, which is very interesting. I'd also like to thank our listeners for being with us today, and I very much look forward to meet you all, including our speaker and experts today with the next Privacy Espresso. So thank you so much, and see you next time.